Good afternoon, everyone. Allison Schaberg here, Consolidated Planning Group. We are happy to be back with the ARC of the capital area and Melissa Donovan today. As you guys are coming in, this webinar is scheduled to go from 12 to 1. So if you're planning your lunch hour, you can know that. Today's webinar is being recorded, and you will get an email either later today or tomorrow with the slides as well as the recording. So you don't have to take every note of every slide or anything like that. You can just be present. We're glad you're here. Your microphones are muted, your cameras are muted, so we can't see you, we can't hear you, but we do know you're here. We're glad you're here. We do want you to put your questions in the chat box. I'll be monitoring the chat box today, and we'll get to just as many questions as we can. A lot of the questions are going to be answered in many of the slides, but your questions are good, and if you've got a question, probably somebody else has that same question. So don't be shy. Go ahead and put that in the chat box. So today, we're excited to have Melissa Donovan back with us from the Texas Trust Law Firm. You may have heard of her before or attended one of these webinars before with us, formerly the WeWall law firm in the Austin area. So today what we're talking about is guardianship, alternatives to guardianship, basically everything that you need to know to start that process. When is it appropriate, when it's not appropriate, and what can we do to prepare for that. So Consolidated Planning Group, we are a holistic special needs planning firm. Melissa and I have done webinars before about why you might need a special needs planner and why you might need a special needs attorney. And the truth is a lot of times there's some confusion on what each of our roles are. And today's webinar is not about that, but basically, in short, they're the paper, they're the legal documents. Melissa, legal documents, the things that you need to have in place as you're planning for your loved one with special needs, things like special needs trust, whether it's first party, third party, guardianship, wills, there any number of things, and basically the paper, and we're the money. We're the ones that help you plan and make sure that you have the money in the right buckets to maintain eligibility for state and federally funded benefits. And also when we're planning for a loved one that has special needs, that may have care needs for the rest of their life, not just ours, we're able to do those future care calculations, Social Security analysis, and things like that. So that's kind of the difference of our roles. They get calls all the time to do what we do. We get calls all the time to do what she does. And so we have kind of made it a point to share that information with the families that we serve, so they kind of understand the lines there. So having said that, thank you, Caleb, for hosting us today, and thank you again, Melissa, for joining us again. And I'm going to turn everything over to you, Melissa.
Thank you, Allison. As always fun to be here. Caleb, I don't know if you wanted to say a few things before we dive into all of the heavy stuff.
For sure, thank you. Yeah, thank you again, Allison, for having us. I'm Caleb from the ARC of the Capital Area. I'm the program manager of our non-waiver case management services here in the Austin area. I am thankful for y'all having us today. For us here at the ARC, I did put a survey in the chat box. If we could please have everyone try to fill that out, that would be really awesome. Part of our outreach program is that we do need surveys filled out just as part of the contract. It's just a requirement. So if anyone is willing to fill it out, we would really, really appreciate it. It helps us keep doing what we do here at the ARC. So I placed it in now in the chat box. I'll send that in again later. And at the very end, if you will just do another real quick survey, it will take like 1 to 2 minutes, that's all. So thank you for having us, and thank you for filling that out.
Thanks, Caleb. So my name is Melissa Donovan again. I am a certified elder law attorney here with Texas Trust Law, the WeWall Law Firm. We just thought it was easier for people to pronounce Texas Trust Law than the WeWall Law Firm. But I know a lot of people here certified elder law attorney, and they think that means I work with old people. It's not really what that means. As a certified elder law attorney, a large part of my practice, the focus of my practice, is special needs planning, guardianship, benefits planning, government benefits, things of that nature. So rather than trying to get all of that stuff into one thing for you guys to learn everything today, we're going to talk about guardianship today. And we are obligated to tell you this. None of this is legal advice. We're going to slide past this one. And here's the big question, because this is the question that I get all the time from clients. I have a child with special needs. I need a guardianship. And I shouldn't even call it a question, because normally when I get those phone calls, It's not a question. Someone has informed them that no matter what, they need a guardianship in place. That is not always the case, and many times it's not the case. There are better alternatives. This is what we commonly refer to kind of in the crowd, as I would say, as a less restrictive alternative. So we're going to kind of talk about both of these things today. We're going to talk about if you do need a guardianship. We're going to talk about if you don't need a guardianship and what that kind of spectrum of options is going to look like for each individual family. So one thing about raising a child with special needs, and while I don't have a child with special needs, I don't have a child period, unless you count my dogs. I work with a lot of families who do, and I know some people may not love this term, but I do believe it takes a village. So when you are dealing with raising a child with special needs, not only do you have to have a group of supportive individuals around you, you're going to have what we refer to as your toolkit. So we're going to talk about proper estate planning. That includes your own estate planning. That includes what you may need for your child to have when they turn 18. That's going to include things like Medicaid and SSI, letters of intent. All of these things kind of come together to form this toolkit that we talk about. Now, in the beginning of this conversation, why are we even having this conversation? Why do we need to talk about guardianship when you have a minor child? Your child's not always going to be a minor. As much as we hope that they would stay forever, they don't. So as soon as your child turns 18, under the eyes of the law, they're an adult. You no longer have the right to make decisions for them. And they may or may not be of a capacity level to be making decisions truly for themselves at that point as well. So if you don't have something in place, you're going to lose the ability to help them out. And that's really the key. You just want to make sure that you're taking care of your kids and that you're helping them out. I don't know if any of you have this experience, but I myself remember going off to college at 17. And the first time my mother could not make my doctor's appointment for me, I wasn't too happy about it. So for me, I could have just done something like a HIPAA authorization. But what happens if you don't have the actual ability to understand and sign those types of documents? And therein kind of lies the main question and the crux of the decision-making process and what's going to be the most helpful for any particular scenario. So like I said, we'll talk about things like medical powers of attorney, financial powers of attorney, and if guardianship really truly is a necessity. And sometimes it is. So the things that we're going to consider when we're looking at whether a guardianship is going to be an absolute necessity for someone is, first and foremost, what's the concern or what's the condition? What is the diagnosis? What is the issue that we have in front of us in regards to the actual individual? Now, you're going to hear me use the term individual because I just really dislike the term ward. Legally speaking, they use the term ward. I don't like that term. So as I talk today and I say the individual, we're talking about the special needs child. Okay. So you may have a child that has severe cerebral palsy, or you might have a child with severe Down syndrome or autism, where it is very clear, and doctors have told you over many, many years that they're not going to be in a situation to be making decisions, that they don't understand how to sign legal documents. You're going to be looking more at guardianship. A lot of my clients, particularly when dealing with autism, don't need it. They get told many, many times by people that they should have it and they may need it in order to make decisions. But when push comes to shove and you have a conversation with the family and the individual, they actually do have the capacity to sign a few things. And there's different levels of capacity for different documents that people sign. So we'll kind of get into that a little bit. The other thing you want to keep in mind are what are the resources out there? So perfect example sitting here today, you have the ARC. Really good resource. You've got community groups that are really good resources that can help you. So don't think that you need to go into these sorts of decisions as though you exist in a bubble. There's a whole community of people around there that are going to be there to help you. And that may be a financial advisor like Allison, it may be an attorney like myself, it might be the ARC, it might be a support group. And those are all things that are in place there. So a lot of this, as you can kind of tell, we're talking mainly about what the individual's abilities and limitations are. And that's where we're going to determine if a guardianship is necessary. And it's funny because we were just having a conversation prior to the webinar starting. personal situations that we've all run across where we know someone doesn't need a guardianship and maybe some third party is telling you that they do. And when push comes to shove, this is the comment I will make to those people. When they say that you need a guardianship and we know that that's not going to happen, if you're in Travis County, I just say Judge Herman's not going to issue it anyway. So there are a couple of types of guardianship that are generally talked about. So you have what's called a guardian of the person and a guardian of the estate here in Texas. Now, if any of you have moved from out of state, these terms will vary from state to state. So a good example, in California, a guardian is the equivalency of our guardian of the person. That's the person who deals with who gets to decide where someone lives, where they work, what their medical decisions will be, those types of scenarios. A guardian of the estate here in Texas is what we call a conservator in a lot of other states. So if you've moved from out of state, just be aware, if you're more familiar with the term conservator, that's going to be our guardian of the estate here. And that just means that's the person who can deal with any assets. Now, truth be told, many times that's not really necessary because a lot of times when kids are aging out and they're becoming 18, they don't have any assets to begin with. If there's no assets, there's no need to go through that giant process with the court. You can kind of simplify things. And those are things that we talk about when we're going through meetings with clients. So those can be full, meaning you're taking away all of the rights that the law allows you to, or limited. You're saying we only need to do these couple of things, but you can retain other rights. And we're going to kind of show you what those rights are in a little bit. Temporary guardianship versus permanent guardianship. I do take a little bit of an issue with the way that we refer to these things because people think of a permanent guardianship, meaning I have to get it and it's in place forever. It's really not the way that it works. With a temporary guardianship, you're more so dealing with something where there's a temporary situation that we need a guardian for this issue to be solved that's really quick. So the reason that I go into that is with even a permanent guardianship, it doesn't mean it has to be in place forever. So a lot of times I get clients who are very concerned because it's not a fun thing to have to go through this process. And it can be an emotional thing when you're thinking, well, I'm taking my child's right to vote or to decide who they want to marry or where they want to live away from them. And I don't want to do that forever. Well, you don't have to do it forever. And really the goal of the guardianship is that eventually, if it's not necessary, it goes away. So it does have to be renewed year to year. So when you hear that term permanent guardianship, I just don't want people to get so stuck on that term permanent. It is renewed every year, okay?
Melissa, can you talk to us about, because I think that a lot of times families are not aware that there is like a such thing as, oh, here it is, partial guardianship. Like, so we have, I guess the ones that I'm talking about are the families that come to us and say, my child isn't there yet. I'm still hopeful and I'm optimistic. He doesn't have the capacity to make decisions for himself right now. We don't really want full guardianship, but we probably need something more than a power of attorney. So I think that we hear that very often because our kids are short on the maturity level. I mean, they're behind their peers anywhere from 2 to 5 years, right? So this is big. So thanks for this. This is good.
Yeah. No, you're absolutely welcome. And that's why I do kind of harp on that permanent guardianship issue, because I think a lot of parents, it kind of scares away a little bit because you hear permanent and you think, we're going to get this, the judge is going to give it to us, we're going to have it forever, but it's reevaluated. And if eventually at 22, as opposed to 18, your child can do things on their own, then you let the court know that in the annual review and the guardianship goes away. So it's not, just because it's permanent doesn't mean it's forever. But this kind of shows you the things that are being done when you do have guardianship over someone. These are the rights that you are taking on as guardian, the role of making these decisions on behalf of the individual that you have guardianship over. So I talked about earlier, guardian of the estate versus guardian of the person. And like I said, many, many times, especially with children who are turning 18, a guardian of the estate is not completely necessary. One question I will kind of tell you an answer in advance, sometimes I do get is, well, what about if I apply for Social Security? So you can get guardian of the person and be basically the payee, it's called a representative payee. You don't need to be a guardian of the estate to act as a representative payee if you're applying for SSI for your child. So this kind of gives you general information. There is some particular information here that is applicable here in Travis County because we're in Austin, but I'll kind of point out where there are some differences because some of this stuff does vary county to county. One thing I will say, and I'm a little biased being here in Austin, Judge Herman, our probate court judge here in Austin, is kind of the guru on this stuff. So a lot of counties are going to follow in line with a lot of the things that Judge Herman does, but not everything. So the one thing I like to point out that is very different, even just one county away. So I work in Austin, Travis County, I live in Williamson County. Travis County requires a $13,000 bond. That does not mean that you have to pay $13,000 to become your child's guardian. That's not what that means. But what it is that Judge Herman requires that you post this bond. Right now it's a permanent bond. It hasn't always been that way, but essentially you're paying an insurance company to back up that if there is something that goes wrong, they will have $13,000 available to cover that expense. Now, other counties, there are some counties that won't require anything in terms of a cash bond or a bond or a cash. Most counties in my experience outside of Travis County, Williamson, Bastrop County, Fayette County are a couple of the ones that I've worked in recently, pretty much require a $100 bond from the parent. So that you just post $100 with the court and they keep it until everything is over and done with. So that is something that would vary from county to county. And these are things that you would want to sit down and talk to an attorney about if you're needing to go through that process. And they would explain all of the intricacies of the county you live in. But most of these things are going to be the same from place to place. So the role of the guardian of the person is, the way I like to explain it, continuing to be your child's parent. So when they were 6 and you decided what clothes they were going to wear and where they were going to live and where they're going to go to school, and you make sure when they're 17 that they are being taken care of and in a safe and healthy environment, that's what you are continuing to be responsible for as a guardian of their person when they turn 18. That's why I like to explain it that way. The court is giving you the permission to continue to be your child's parent the same way that you were the day before their 18th birthday. Now, not everybody qualifies to be a guardian. We will kind of talk through some of the things that would disqualify someone from being a guardian. But this does kind of show you what your roles and responsibilities are. Now, I mentioned earlier, if you get a guardianship, even a permanent guardianship, you do still have to renew it annually. And that's where that report comes in. So what would happen is you have to file a report with the court every year that explains how your child's doing from the last time that they may not have been in front of the court, but that you were there, what the change in situation has been, if there even has been a change in situation, if the health condition has gotten better or worse, has there been a change in where the person is living? You're going to let the court know that over time. And that's where I was saying earlier, eventually you may get to a point where when you're filling out that report, you're going, my kid doesn't need this anymore. And then you can tell the court that, and then they will terminate the guardianship. So sometimes people have health situations that it's going to be required to stay in place forever. That's not always the case. So keep an open mind when you're going into this stuff.
So, Melissa, I anticipate with the number of people that are on our webinar today that we have people that are not in Travis County, and I know that your experience is a lot with Travis County and kind of out that way. So is it fair to say that, each county is a little bit different and what they demand and what, how the judge is and things like that. So it's not, so the process of guardianship is similar, but the requirements are a little bit different. And is that right?
That's a good way to explain it. The general requirements under the law are going to be the same everywhere, of course. The procedural issues will vary county to county. You'll notice some counties are more formal than other counties. Usually your smaller counties, I'll use Fayette County as an example. When I've been in Fayette County, it's a little bit more relaxed and casual than it is here with Judge Herman. Like I said, Williamson, Bastrop, Fayette County, a much lower bond. To tell you the truth, ultimately it ends up not costing that much less because a $13,000 bond here is about $225, a $100 bond that you're just putting $100 in cash with the court. not a huge amount of difference in terms of what the parent is paying, but it's just a little bit of a difference in those types of things from court to court. You'll notice also in terms of the procedural issues prior to getting to a hearing, some courts are more lax in what they require from attorneys and ad litem's. Others are a little bit more strict. I will tell you, Judge Herman falls on the little bit more strict side of things, but that's not a bad thing. That's actually kind of cool.
Well, I was wondering if you could address, so basically the premise of the Texas law is the least restrictive option that is the best interest of the individual. Since we don't like the word, I agree with you. But let's talk about that, because there seems to be a slippery slope that we talk about on a pretty regular basis. When we have kids, when the state of Texas basically identifies intellectual disability of an IQ of 70 below or 69 and below, some would argue that if your loved one has an IQ in that range, that they don't have the capacity to understand what they're signing if they're signing a power of attorney or a healthcare power of attorney, which would clearly be less restrictive than guardianship or partial guardianship. So that's a slippery slope. How do you address that, and what is the right answer on that? Because I think there's some misinformation about this.
Yeah. So the first thing that I will say, and I know you and I have had this conversation before, as an attorney, I am going to lean on a doctor's determination on how they feel about things first and foremost. So one thing I hadn't really touched on just yet, and I'll just kind of mention it briefly, is with any kind of guardianship, there is going to be a medical determination. It's called a physician's certificate of examination, where a doctor who has seen the child, who has examined the child and has some knowledge about their background, is going to go ahead and let you know what their thoughts are, what their IQ is, what the disability is. Do they believe that the child can actually do things? Now, that being said, is it possible that someone with that IQ around 70 could avoid guardianship? Possibly. It's not always necessary. And the thing with capacity is, as I said earlier, there's different levels of capacity that are needed for various things. So the capacity that I need to sign, for example, a will, is actually quite less than the capacity I need to sign a financial power of attorney. There's what's called a supported decision-making agreement, which I know you both are well aware of. Maybe some people who are with us today are not familiar with that. To sign that, you don't need to have as high of a level of capacity as you do to sign a financial power of attorney. So I know people hate that answer from an attorney, but it really does depend on the scenario and being able to kind of make those decisions, taking in all of the information from what the doctor has stated as their opinion. And if there is that at least minimal ability to maybe sign a supported decision-making agreement, and I am a fan of supported decision-making agreements, but they're not good in all scenarios, of course. So it really is a one-on-one determination as to, for any individual child, what's going to happen.
Let's talk about the supported decision-making just for a second. Because some people would argue that a supported decision-making agreement isn't even worth the paper that it's written on. Don't parents help their kids make decisions anyway? Do we really need a piece of paper for this if we have a power of attorney or a healthcare power of attorney or those types of things? So is a supported decision-making an actual legal document, or is it tell us about that? I mean, what do you, and I know it's like not all states have supported decision making, right?
Yeah. Interestingly enough, to my understanding, Texas was actually one of the first to have supported decision making agreements. And it's a contract. It is a contract that you're signing. So I'll give you an example. I have a client, and this is a very unique situation. So I have a client I met with last week. She's actually, you meet with her, she's a very astute 18-year-old girl. She has a very rare condition that she is what we would call neurotypical on a regular basis. But if she gets at all sick, her brain swells and she appears to have no capacity whatsoever, like that. So it's a pretty unique scenario. So for her, she wouldn't really get a guardianship because she doesn't have the need for that on a regular basis. She does have the capacity to sign a power of attorney, but she wants her parents to be able to help with things that a power of attorney doesn't help with. So let's say she wants her parents, which she does, to be able to talk to the school about non-medical things. So here's where these things kind of all connect, is that a medical power of attorney allows someone to make medical decisions for you. A financial power of attorney allows someone to make financial decisions for you. They can deal with third-party organizations, government organizations like Social Security and Medicaid, but what if there's an issue at school? Neither one of those things really connect to those issues. So that's where the supported decision-making agreement does come in handy. Now, you would always sign a HIPAA authorization. And for anyone who may not be aware with what that is, HIPAA is just the federal privacy law that tells your doctors, people with your medical information, your private health information, they can't give it to anyone. So that's not just doctors, attorneys are included in that, anyone who would have protected information. So the HIPAA authorization is going to let those people know, okay, you can share this information with this. The supported decision-making agreement is a contract between the daughter and mom, or the daughter and dad, whoever it may be, saying, I am okay with you, organization, sharing as much information as possible with this person so that they can assist me in making a final decision on what I need to do. It's not guardianship. It's not saying they can make the decision for the person, but it's giving them the right to access the information beyond medical and financial that they wouldn't really otherwise be able to get. And that's where, because I was on that line when I first started learning about supported decision-making agreements, I will admit it, I was one of those people. What is the point of this? It's not worth the paper it's written on. I've come around over time because there are situations where it does help. I will say there are certainly situations where I would go, it's useless. But there are certainly situations where they can be very, very helpful.
And I think there's situations that the general world as we know it, or people in Texas don't understand or even know what a supported decision-making agreement is. I mean, we've actually had some people run into that. One of the things that you were just chatting about was, I think that the medical form that's going to have to be filled out by a doctor certifying that there's a need for guardianship and stuff like that, which brought up something that usually comes up every time we talk about guardianship. Kind of about the process. What if we have a family that has had an adversarial divorce? There's a custody arrangement. Maybe the child lives with one primary parent, but the other parent has visitation. The other parent is adamantly against guardianship, but clearly there's a need for guardianship. Can we just address that for a second? Because that's something that we hear about at least a couple of times a month. It's not something that's unheard of.
Yeah. Funny thing is that when there is divorces, there's a lot of things that can get contentious. So here's what can happen is that if there's a need for guardianship, there's two kind of pathways when you're dealing with guardianship and the actual process. So there's one pathway, which is everybody is in agreement. This is what we call an uncontested guardianship. There's nobody who's going to say that this is not necessary. And that's always going to be easier because there's nobody disagreeing with anything. Now, if let's say mom is saying that there's a need for guardianship and dad is adamant that there's not, we've got the physician's certificate and the doctor is essentially agreeing with mom. Here in Travis County, Judge Harmon does give a lot of credence to that physician certificate, but it's still a legal proceeding. So if dad is going to contest, when you go into a guardianship and you apply for guardianship, there are certain people under the law that have to be notified that you are doing that. So parents need to be notified, adult siblings need to be notified. If you're dealing with an older adult, let's say there's a spouse, spouses need to be notified. Children need to be notified in that scenario. So every scenario is different as to who you're trying to get guardianship over, but the law lays out who needs to be notified of the proceedings. And that's kind of the point of that. Because if mom goes to get guardianship and doesn't notify dad, then we're in trouble. So mom is notifying dad, then dad has the right to contest it. So there'll be a hearing. And the judge is going to hear evidence from all sides. And that's the judge's call. That's the judge's role, is to make that determination after hearing all sides. as to what is in the best interest of the individual, because that's always what it really comes down to in the long run. What's in the best interest of the individual, not what's in the best interest of mom or dad. Not to sound harsh, but that's what it's about.
Thank you for that. That's perfect.
You're welcome. So this kind of going through that gives you a little bit of a rundown in writing of what we just went through. So kind of that process. When you go to apply for guardianship, you're going to put in an application with the court. The attorney, if you're working with an attorney, the attorney is going to file that paperwork, file the physician certificate, and then the court is going to appoint what's called an attorney ad litem. Now, if you are hiring an attorney to help you with your guardianship, that attorney's job is to represent you. So an attorney can't represent people who have adverse interests to one another. And in essence, if you're trying to get guardianship and take someone's rights away, your interests are adverse to one another. So the court has to appoint another party to represent your child. That's what we call the attorney ad litem. Once they're appointed, that ad litem is going to meet with you and your child. Now, we're kind of coming out of it, thankfully. But over the last few years, a lot of that's been done on phone calls and Zooms. Prior to that, it would usually be an in-person meeting. It's going to be kind of all up to the scenario. And sometimes the health condition of your child is going to dictate that it's not going to be in person. So that's something the ad litem is going to work with you on. I will say in my experience, most of the ad litems that I've worked with on my guardianship cases are very well versed in these things. Most of the people that are on those lists, particularly here in Travis County, are people who are pretty well versed in guardianship. Maybe they're estate planning attorneys, maybe they're, people who do guardianship all the time and they don't do estate planning. Every now and then I'll get an ad litem who's like a criminal defense attorney, and they might do things a little bit differently than the guardianship attorney does. But overall, they do have to go through training. They do have to have four hours of CLE every 2 years. So we have to get certified to be able to do guardianship work. So the point of saying all that is, in my experience, generally speaking, when the ad litems reach out to you to have those conversations, they're very gracious in doing so. Don't expect that you're getting, the super tough defense attorney from Law and Order that's fighting Jack McCoy. That's not really what you're getting. Okay. Did you have a question, Allison?
Yeah, two things. One person mentioned, and this is a very good point, so thanks for putting that in the chat box, that if your young adult is attending college, some programs will not accept a person if they're under guardianship, and that is true, and it is different for each college and program. I mean, there are programs specifically for kids with disability. You can check out Think College. We have a webinar coming up on college for special needs, but that is true. So thanks for saying that. And then another person said, basically the question is if they have full custody, of the individual, would the parent, the other non-custodial parent, have any say in guardianship or not?
When they say they have full custody, all rights would have had to been cut off from the other parent for them to not have the right to notice.
Mm-hmm. Now, in the example, and we do divorce meetings on this too, but in the example where a person has full custody and full decision making for the kid, what about in that example?
Even still, and this is where with a lot of clients I have to make the kind of precatory statement of it can depend on what's in the divorce decree, but generally speaking, those rules cut when their child turns 18. So that's no longer applicable as of the 18th birthday. And then it's up to anybody, it could be mom, it could be dad, it could be either parent, it could be a sibling. Maybe neither mom nor dad think there's a need for a guardianship, but the older sibling really thinks there is, and maybe the sibling is the one who's going to go try to get guardianship. So once they're 18, I know we always kind of talk about mom and dad. It doesn't always have to be mom and dad.
Right. Okay, so two other things that come up on a pretty regular basis, being in Texas, what if the other bio parent is out of the country or is not a U.S. citizen? What if, there just needs to be an attempt for them to be served, or basically tell us what happens for that?
So there needs to be an attempt to serve. And this is pretty similar across most guardianships, probate situations, anything like that. You can't just say, oh, they're out of the country, I don't have to do anything. You have to attempt to serve them. And if there's no capability of doing so, then it's going to be the judge's determination as to whether or not they will move forward. Again, based on all the circumstances and what effort was put in.
Okay, so one important thing that I want you to touch on is moving counties in the state of Texas. And what if you have guardianship from another state and you are either moving to Texas or you've recently moved to Texas? Can we talk about that?
So if you have guardianship, the answer is kind of the same for both. But if you're moving from out of state, you absolutely need to get that guardianship renewed here in Texas. So the process will be a little bit more streamlined than an initial guardianship if you had nothing in place, but you do still need to get everything transferred over here to Texas. Now, if you're moving from one county to another, again, you still need to get that moved over. So if you, let's say we're living in Fayette County and you move to Burnett County, then you're going to want to reach out and update that guardianship and get it transitioned over into Burnett County. And then that way, because what happens is that everything is based on what's called jurisdiction. And once that person, once the individual no longer lives, in this example, in Fayette County, then technically the court in Fayette County doesn't have jurisdiction over them any longer because they're not there. And same thing with moving from out of state. If you lived in Oregon, then Oregon courts had jurisdiction at that point. But if nobody's living in Oregon anymore, they don't have jurisdiction, and nobody here has any knowledge about the guardianship yet. So you've got to get those things moved around. Now, there's flexibility on timing, and more so if you're moving county to county, especially, let's say someone's moving from Williamson County to Travis County. Are you going to have an issue when you're dealing with third parties? Probably not. But technically and legally, you need to get it transitioned over. And if you don't do it beforehand, when you do the annual report every year, the court's going to make you do it at that point when you're honestly telling them, hey, we don't live in Williamson County anymore. We live in Houston now.
And just to clarify
So, and this is,
sorry,
oh,
Allison,
yes.
just to clarify one thing, and that's when the ward moves counties, correct? Not
Yes.
necessarily the parent, but the ward.
Yes, I know it gets confusing because I keep using the term individual.
I like the term individual better too. Caleb, that was exactly what I was getting ready to say, because one thing is some families have kids that are in residential facilities outside of the state. So if they're living like a long-term residential facility outside of the state, is it true that the guardianship should be in the state and county in which the individual is living?
It would be based off of where their permanent residence is at that time. So if their permanent residence on everything is still Austin, Texas, versus wherever the facility where they're staying at that point in time is, those things can change.
And I guess what my question is so you take permanent residence. We got kids that go away to college, their permanent residence is home, right?
Right.
And so I get that. But what about when you're in a state and the laws are vastly different, or the state or the facility itself, they simply just won't recognize your out-of-state guardianship? Is that a thing?
So to be completely frank with you, this is not a scenario that I have dealt with personally in my practice. I could imagine a scenario where that's going to be a problem, and you may need to get it transferred over, or at least do something in maybe both states.
Can you provide us the name of the form? Isn't the county supposed to reach out to the family annually for this renewal? Because we had somebody in the chat box that indicated that they were unaware that it needed to be renewed annually. So in the example that a person doesn't fill out this form that you were talking about, do they just have their guardianship revoked? Like, what happens? Is it like punitive? Like,
I'm wondering what county that is, to be honest with you. But yeah, so the court typically will reach out. They'll usually send out the review. It's the annual report on the condition of the word that we don't like, the ward. But typically that gets sent out about 60 days prior to the renewal date. The renewal date would be the day that the judge signed the order. So if, let's say, we got guardianship on January 1st of 2022, I would expect to receive my reminder from the court sometime in October at the latest, or excuse me, that was January, sometime in November. Now, can things happen where it doesn't arrive? Sure, sometimes things happen. But if it were me, and this is what I advise all of my clients when we finish up a guardianship initially, pop it in your phone. You can always reach out. Most courts, and I will tell you that even if you're not in Travis County, the Travis County Probate Court's website, Judge Herman's website, is probably one of the best resources that you can have when it comes to guardianships and paperwork for guardianships. Most courts will have some of their guardianship forms available online. Williamson County does, Travis County does, even Fayette County has a couple of things on their website that you can pull. But if you don't see what you're needing, if you don't see that annual report available on your county's website, call the clerk. And if you call the clerk, they're going to get it to you. They'll email it to you, they'll mail it to you, but it's really important. That report is due within 60 days of the renewal date. So you need to make sure you're getting that.
So, or what? So if in the event that you've missed the 60 days of the renewal date, and it was Harris County, which is Houston, greater Houston area, and in the event you never got this document and they blame COVID on their inefficiencies, whatever. So what happens? I mean, is your guardianship done? Do you have to reapply? I mean, like, what happens?
They may require you to do that. They may go back, and particularly if you use the COVID excuse. I'm guessing they're still letting that fly for a little bit longer. So if you use it, they may accept it at that point, and then, but you just want to, moving forward, make sure that you're getting everything, and double and triple check yourself on things like this. Like I said, put it in your phone. One thing I can say, and I don't know if anybody or everybody has had this experience, even though things are supposed to happen, don't count on anyone else keeping you on track. You want to make sure that you're keeping those calendar dates yourself too.
I agree with that on your local authority. Like if you have your child on the state interest list, like, HCS, Texas Home Living class, all of those, your local authority is supposed to reach out to you every 2 years, verify you still want to be on the list, let you know where you are on the list. Some local authorities do a great job at this, some don't. Some used to, and they didn't for the last 2 years of COVID. So that's another thing, is to follow up with your local authority and make sure where your child is on those lists. So we have a couple of things in the chat box that I want to hit on, and this is a good one. Thanks for putting this in here. Can multiple individuals be named as guardians? So does it have to be a husband and wife, or could both bio parents be guardians? How does this work?
So I'll tell you what, in my experience, so only husband and wife parents can be co-guardians. Judge Herman will not appoint anyone else as co-guardians other than mom and dad married. So if mom and dad are divorced, it's going to be one of them that's going to be the guardian. I get clients all the time so I do a lot of estate planning as well as guardianship. So let's say we're doing a declaration of guardian for our minor children, and they say, well, I want to name my brother and his wife. We're not going to do that because we know the judge is not going to appoint them together. There are other reasons not to do that, which are more of an estate planning conversation than a guardianship conversation. But usually they're only going to appoint parents who are married as co-guardians, no one else.
Now, and when they set their guardianship up for the first time, is there such a way that they could set up a successor guardian? So say I'm guardian of my child, and I want to name somebody else as successor guardian in the future. Can I do that on the front end as opposed to having to back up and punt at my death?
So you can sign, so I just mentioned a declaration of guardian for minor children. If you are guardian of an adult incapacitated child, you still can sign that. Now, one thing I will tell you, because I even tell this to my state planning clients about minor declarations, it's not an obligation of the court to follow it. Now, will they? Probably. So long as the person is not disqualified and they're fit and the court deems it, again, in the best interest of the individual, then they're going to follow your wishes to the best of their ability to do so. So something that you're going to want to do. Now, some courts will actually ask you to file that with them. Others won't. It just depends on the particular area. Here in Travis County, I've never had a client actually file that with the guardianship. In some other counties, I've seen people file it with the court.
What about, some of our kids are transitioning from a healthcare perspective from pediatrics to adulthood. And so when we're getting this physician statement filled out, is it best to have it filled out with the doctor that has the longest history and records of the child, or is it okay to get it filled out with this new primary care physician that's on the adult side?
Yeah, so this is kind of a could versus should. Can you get it filled out by the new doctor? Yes. Should you? No. You want to do it with the doctor that has the most background in history. And this is more from, and I'm not a litigator, but this is more from a litigator's perspective, I would say. You want to make sure that you're going in with the biggest guns that you can. If I'm going in with a doctor who has very little prerequisite knowledge, and then someone's going to contest this, I'm sitting in a dangerous situation. Whereas if I'm going in with a doctor who's seen this individual for 18 years, 15 years, that's going to hold up a lot stronger if someone's cross-examining this doctor in a contest. So that's why I say, can you have the new doctor do it? Yes, but you should, I would recommend doing it with the old. And sometimes you'll do it with two. So maybe you do it with both. Or maybe it's a scenario.
And I wanted to ask about like the psychologist or psychiatrist, because sometimes we have kids that are a threat to themselves or others. They have mental health issues, and the bulk of those records are with the mental health provider as opposed to the primary care physician that you take your kid there for strep throat, So in that example, is it best to have it done by the mental health doctor?
I would, now it doesn't hurt to have the primary care physician do one as well. And also because kids can have multiple diagnoses. So for an example, I have one client who is autistic and also blind. So we have one physician certificate from the neurologist and one from more of the traditional doctor regarding the blindness. So you don't have to just have one. You don't have to have more than one if there's enough proof and evidence in the one. But there are certainly scenarios where you'll have two or maybe even three. It just kind of depends on what the actual medical conditions are that are causing the delays.
And Melissa,
and I would also say that all physicians are different, but a physician that just met your child, they would be hard pressed to make a case to sign off on the guardianship form. I mean, it would be almost questionable if they basically didn't know your child and you're signing up to take your child's rights away. It's almost a questionable practice for a brand new doctor with no history to sign off on that, really.
Yeah. It looked like you were about to say something, Caleb.
Yes, I had a question. So what is your feeling on DIDs, or determination of intellectual disability, from the local authority to replace the PCME or the physician certificate?
I've never utilized that, to be honest.
That's something we do here at the ARC for our guardianship program, is with Judge Herman, is we actually use the DID in replacement of the PCME, and we only use the PCME if we're not able to get a DID from the local authority, especially with current times and their backlog and time to get an eval. And I think the reason why we've been using that is because it's such a big narrative, 30-page paper filled out with all this information. I think that's why we use it. So I was just curious what your opinion was on that.
Yeah.
So, and tell everybody that you use the acronym. We throw these acronyms around, what that stands for.
It's determination of intellectual disability, and that could be given to you from the local authority. Here in Travis County, Integral Care requires that to start receiving services for them, even in general revenue. And it's a very intensive 3-hour-long eval where they write up a huge narrative and explains the child from like their whole life and now where they're at, even an IQ score, all kinds of stuff. And so for our guardianship program that we offer here at Lowcost, we tend to use the DID to move forward. But if the DID is not within 2 years old, because they don't have to redo them only every 5 years, but if it's not within 2 years, we can't use it. So we go forward with a PCME instead, or a physician's certificate.
So everybody, your local authority is by county. So everybody has a local authority. Harris County is going to be the Harris Center. Fort Bend County is going to be Texana. You had mentioned, was it Bluebonnet? I'm sorry,
Williamson.
I forget which.
Integral Care is Travis.
Okay, so anyway, your local authority is by county, so they can do these assessments at your local authority, and the point of the assessment is to determine the LON, the next acronym of level of need for care, and so those are assessments that can be done by your local authority without charge and things like that. So just since we're mentioning that, local authority, your local authority is also where you get your child placed on the interest list, like for Texas Home Living, HCS, Community First Choice, things like that. So if you're wondering how to get your child signed up for the waivers interest list, they maybe aren't on the list yet. We have a whole webinar on waivers and how to do that, but your local authority is how you get them on the list, and as backwards as it seems. There is no like website that you go to and you log in and you put your child on the list, or you log in and see where your child is. You really do have to call your local authority and get on the list, is basically how it works. For now, hopefully we'll have some changes to that soon. So back to you, Melissa.
So I think we kind of clearly covered who can act as a guardian. The one thing I do like to kind of point out, one thing that's always said, even I'll hear attorneys say this, if someone is a felon, they cannot be a guardian. That's not technically what the law says. You don't have to be a felon to be disqualified from being a guardian. It's a notoriously bad conduct of history. So I don't run across that, thankfully, too much in my practice. But generally speaking, most parents should qualify to act as guardian. Most parents are not in lawsuits against their children or anything like that. So kind of stepping away from the guardianship side of things, because truth be told, the hope is to avoid guardianship. A long time ago in this conversation, I made a comment about people saying you need guardianship and me bringing up, well, Judge Herman's not going to issue it anyway, so don't even bother fighting that fight. So I say that because most people who practice in this area and judges who are like Judge Herman, who are probate court judges, who this is what they do, they don't want to issue a guardianship. I know a lot of people think the opposite. Everybody's heard about the Britney Spears story and all that sort of stuff. This is not the goal, okay? So the goal is that your child, the individual, is going to be able to maintain as much independence as possible. Guardianship is not necessarily that. So these are some other options. So if there is enough of a capacity level that your child can understand and sign a financial power of attorney and a medical power of attorney, that's always going to be what we recommend. There's no need to go to court to make your life public record, to get a judge involved in things if your child can sign these documents. So if they can sign a power of attorney, they're going to sign it. And if you have a financial power of attorney, if you have a medical power of attorney, then you're going to be able to help your child with those decisions. Now, the other side of that, going back to the supported decision-making agreement earlier that we talked about, in relation to a medical power of attorney, this is also an important difference, because a medical power of attorney doesn't give you the right to make a decision for someone who can make the decision for themselves. So that's another one of those kind of lapses in there between medical power of attorney and a guardianship. That's where the supported decision-making agreement can come in to fill that gap, because the medical power of attorney says, if I'm incapacitated, this is who can make my medical decision. If I'm not incapacitated, they don't have a right to do it. But if I still don't have enough of an understanding to really understand what the consequences are of making a decision, maybe a surgery, and I have that supported decision-making agreement to go along with it, well, then my mom and dad can come in and help me make those determinations. So those are the kind of situations where a supported decision-making agreement, you really can see where they are of benefit.
Okay, and I know that all attorneys are different, and we do have attorneys that we refer to all across the state. So no matter what county you're in, we do have, people. Certainly, Melissa can help you in her firm. But there's always this pressing question. So I know it's all different.
I know
but
what it's
can
going
you
to
just
be.
give us a range? Give us a range of how much guardianship or partial guardianship costs, because we need to plan financially for this if it's going to, be a pretty penny. So can you just give us a range?
Yeah, I'll give you a range for kind of the area that we are in. So Travis, Williamson County. I would say in this county, if you're hiring a private attorney to do guardianship, you're looking anywhere between $4,000 and $10,000, depending on the attorney and the type of guardianship that's necessary. Meaning, is it just a guardian of the person? Is it a guardian of the estate? So on and so forth. And again, the attorney level of expertise, are they downtown? Are they in a small county outside of downtown where rent maybe not so expensive? Those are all practical things that do go into how attorneys actually do charge fees. But I would say that's a pretty good range that you could expect.
And I think for Harris, I think that we've seen on the low side around 2,500, probably to 7,500, probably for the Harris and surrounding counties. And that brings us to Caleb, because there is a program through the ARC of the capital area that Caleb is over, for families that of modest means or indigent. So talk to us about that, Caleb.
Yeah, for sure. Thank you. Yeah, so here at the ARC of the capital area, we actually do offer a low-cost guardianship program. I believe it might be one of the few of its kind in the state of Texas. It is specific to those living in Travis County because it is a county-funded program, and we work really closely with Judge Herman's office, and we get pro bono attorneys who help us through the process as well. I believe at maximum we can serve 15 families. It's cohort style, so you apply for it, you come in, we do the whole thing with you, go through all the paperwork, and then actually end guardianship with you and are there at the court when you get awarded it. It is low cost, so you have to be 250% or below the federal poverty level. And it will cost $250 for the program for our paperwork. And then with the bond, this year we were able to have the courts actually cover lifelong bond for our families, which is awesome. That's the second year they've done that. It doesn't mean they'll do that every year, but we've been lucky enough to have them do it the last 2 years. But so the families that I have right now, they only pay $250 for their guardianship, which is awesome and unheard of usually. So.
Wow. So the 250% below the poverty level. So for families that are wondering, do I qualify for this? Basically, if you have minor children and they're getting SSI and Medicaid, the answer is probably yes. The other thing is if you have private health insurance through healthcare.gov and you're getting subsidy, like an offset of your health insurance premium. So the answer is you very well may qualify for that. So if you're wondering, so the number is pretty low, but families that are in that situation, definitely may qualify for that. So I think that we are running out of time. So I'm gonna give it back to you, Melissa.
I just want to say real quick, one last thing. If you are curious and you feel like you might, feel free to reach out to me and I can make sure that you qualify or not.
Thank you for that. And by the way, there's a program similar to this. I don't have all of the details in Galveston County. I do know that there's a program like this in Galveston County that's either cheap or actually I even think it might be even free. So if you're in that area, it is worth it for you to check out. And I'm not even sure that program is for indigent. You just got to check it out there. I think that they got a grant or something in Galveston County. So just wanted to mention that as well.
Yeah, no, and I think it can be a really good benefit because certainly, not everybody can afford to hire a $5,000 attorney, and having these resources is really, really important. So I know it sounds cliche, but I'm really glad that you're here, Caleb, because I was not even familiar. I've been familiar, we were chatting earlier, with ARC of Texas for quite some time, and it's nice to know there are services that we can kind of share with clients who need it done by a qualified person. So I know we have not hit on everything, but I also know that I can talk a lot, as can Allison, get the two of us together and we take an hour, and we don't always get all the way through the slides.
Same
But
here.
this does kind of run through the other things that we would recommend. So medical, financial power of attorney that we've talked about, you do want to make sure you've got, if you're not needing to go the guardianship route, you want to make sure there's a HIPAA authorization in place. Now, this also goes through some easier things on the estate side of things. So if, let's say, someone has a checking account and you're not quite needing a guardianship of the estate, durable power of attorney is good. Maybe you want to add a convenience signer on the account. Maybe it's a joint bank account so you can control where things are coming from, so on and so forth. So there's a lot of different options out there that can kind of combine to make sure that if there's not a full need for a guardianship, there's still the ability to help and make decisions for your child. I know we've talked about the supported decision-making agreements kind of scattered throughout the last hour. This gives you, I don't know how interested all of you are in reading code, but if you want to later on, you can always go ahead and do that here. But we've kind of talked through that. Like I said earlier, when I first found out about supported decision-making agreements, guilty as charged, I was that person that said, what is the point of this? In 7 years of doing this now here at this firm and getting more familiar with these documents and seeing how they can help clients, they're far more helpful than I gave them credit for up front. I will admit when I am wrong, and I was wrong. Now, did we have any other questions on anything?
I think we're good. I think we're good from a chat box. We've got a little after 1, so we're going to wrap this up. You can forward the slides to our contact information. Guys, all of these webinars, we do webinars on a weekly basis on all topics surrounding special needs. They all live on our Consolidated Planning Group YouTube channel for free. You can subscribe to that, and you can go back and kind of, listen through. You are going to get a copy of today's slides, all of them in the entirety, so you can have that for your reading enjoyment later. Thank you for taking the time, both of you, to be here and to put this together today. Thank you, everyone, for attending. I hope this information was helpful to you on your journey. All of these webinars are designed to give you the tools and resources that you need for free to kind of learn how to navigate some of these things, because it is hard and it feels a little overwhelming at times, but we hope to make your journey a little bit easier. So thank you both for being here, and I hope that everybody has a great afternoon.
Thank you. And just real quick before we go ahead, one last thing. If you're wanting to support a document, if you go to arcaustin.org, under our programs, under Family Juvenile Transition Services, you will find the ARC of Texas's original supported decision-making document there. So just so y'all know.
Thank you for that. Caleb, if you want to email that to us, we can include that. We can just actually include that attachment to everybody when we send the slides and the recording. So sounds great. Good. Thank you so much. Take care.
Have a great day.
Bye, everyone.
Bye now.